Good evening. This is Tim Markle. I'm Director of the Southern Regional Center for Children and Youth with Special Healthcare Needs. On behalf of the Greene County Community Arm Transition, I welcome you to our final session of 5 county transition talks in May. We have been covering topics such as transitioning from high school to college, living as independently as possible, discovering yourself and your community, finding my meaningful day, and disability law against the lifespan. We are finishing out our series with Tami Jackson from the Board for People with Developmental Disabilities. She is going to be talking to us about supported decision-making and decisions about guardianship. Tami is a public policy analyst and legislative liaison for the Wisconsin Board for People with Developmental Disabilities, and we are very excited to have her here tonight. Tami, welcome.
Thank you so much for having me. This is one of my favorite topics to present on, not only because I was intricately part of getting this law passed in this state, but because I think it's such an important discussion to have with parents and that professionals need to be aware of as well as we think about who makes decisions and what people's rights actually are. I usually spend a lot of time on this slide, and I'll always preface it by saying, you know, the law actually presumes that everybody has the ability and the right to make their own decisions, unless that has been formally taken away by a court. So I think that's really important, you know, as we're talking about parents and thinking and looking at young people who are becoming adults. Everybody makes decisions all the time. And sometimes we make good ones, and sometimes we don't. And even when we don't make good decisions, we do tend to learn from them. Everyone has that capacity to make good decisions, to learn from bad decisions, and to consult with others about what they think about a certain topic and look at their options. So this slide, folks have found helpful. We kind of have an array here. Some people like to call it a continuum of, well, if you need help making decisions formally, what are some of your options? And if you see the green column, that's kind of the least, where we're calling the least limiting, the least restrictive. The green column, we're starting from that position and moving our way towards the purple column. And when you get to the purple column, that is the most extreme thing that you can do. On the green side, you are making all of your own decisions. On the purple side, somebody else may be making your decisions for you legally. So we're going to go through these options, and I'm also going to do a little bit of editorializing because I do work with a lot of parents and older adults, frankly, who are having very few conversations about future planning and are often surprised at the differences between these colored columns. So starting with the green side, a lot of times if you're at a doctor's office or at a bank or some other professional organization, you might be asked to sign a release form. And usually none of us question that. We just go, okay, and sign it. But really what you're signing is permission for somebody else to see whatever that professional is keeping for you. So some release forms are time limited, or they're only good for one visit, or you sign a release form for every person who's seeing information. There's a lot of ways to do a release form. The key component here that I want folks to understand is that if I sign a release form, I'm not giving up any civil legal rights of my own to make my own decision. I'm allowing somebody else to see some information once or maybe continually until I say no. I'm always in control of my own information. And this release form is basically me acknowledging that I would like somebody else to see it. Okay, moving to the next yellow column. Now we start talking about supported decision-making agreements. And I have in parentheses Wisconsin, because I think we are one of about 12 states now that has a law in the books that says, hey, this is actually an option for people. Often it is presented as an alternative to guardianship, and we'll get to what guardianship means later. And of course, like many things between states, the laws vary. Wisconsin was actually the first state to decide that supported decision-making agreements had a wider use than just people with intellectual and developmental disabilities. So we actually broadened our law, and we'll talk about who can use one in the state in a little bit, to make sure that folks, anybody who has we call it a functional impairment, but that this is really a useful tool for lots of different populations of people who don't have any need to have somebody else make decisions for them, but do have a need for somebody else to do certain functions and help them understand their decisions that they're making. Interestingly, every state that I'm aware of who has followed Wisconsin in creating their law has taken what we did and gone even further. So there are now states who went, oh, Wisconsin did this. Yeah, it does seem like this is a really useful for lots of populations of people. There are now some states where actually anybody can use a supported decision-making agreement. You don't even have to have a functional impairment. It recognizes that, frankly, this is how we all make decisions, right? You know, I like to say about formal supported decision-making, the person is always in charge of their own decisions. The supporter has a very limited but important role in helping them either understand information, understand options, or communicate the person's decisions to others. The supporter doesn't gain any new rights. They're not making decisions for you. And this is how we make all of our decisions. If I I don't have a functional impairment, I wouldn't be able to use this option in Wisconsin, but sometimes I might call Tim and ask his opinion on something, right? Or, we have that network of people like, oh, I'm trying to buy a new car. What should I do? And you use your network of people who you know, who you trust, who has some sort of expertise to gather some information and insight, and you make your own decision. We do it all the time. This is just a label for it. And we have the law, frankly, because so many professionals and providers assume that if you look a certain way or have a certain kind of condition or are a certain age, that you must not be able to be capable of making your own decisions. Not true, but that is part of the legacy that especially people with disabilities live with. The blue column, now we're starting to get to the point where someone else is actually involved in making decisions before somebody else. Many people with disabilities are part of Social Security at either SSDI or SSI, and sometimes there is a person called a representative payee. That representative payee is somebody who actually receives all of the cash benefits that Social Security and SSDI pay out, and they are the person who is in charge of releasing that money. So in this sense, the representative payee becomes kind of the gatekeeper for that person's cash benefit, and the person essentially loses their ability to manage their own money. So that is at least when you get to the blue column, now you're starting to get, it's a point where, okay, you are not in full control of all of your decisions. Rep payees are really only in control of those cash benefits. But if that's the money you receive and somebody else is in charge of how you spend it, that's pretty significant. Most of us don't get very far without access to our funding. Moving to the red column, lots of people know about powers of attorney. Relatively few know what they actually are, including professionals, to be honest. And again, powers of attorney can be written in different ways. There's two different kinds in the state: powers of attorney for healthcare and powers of attorney for finances. And most powers of attorney are written in a way where they are not always active. They are triggered when a certain set of conditions is reached. So for example, in a healthcare power of attorney, let's say Tim is my healthcare power of attorney. Tim doesn't get to decide all my medical decisions whenever. But if I am ever in a place where Tammy's in a coma and the doctor says this person is not conscious and cannot actually decide what to do next, then that power of attorney is triggered, and temporarily Tim steps in and makes those decisions for me. Now, I may recover, at which case my power of attorney goes, Tim is still my power of attorney, but he no longer has to make my decisions because I am, again, competent, right? Or maybe I'm in a coma for a really long time and Tim is now in charge long-term of making some of those decisions for me because the conditions are right where that is triggered. Some people write it a power of attorney where the power of attorney has kind of co-equal decision-making authority. Sometimes that's called a durable power of attorney. And sometimes you see that with financial stuff more often where, and often with older adults where, the power of attorney has exact access and equal ability to pay bills and other things. If you're the person, you better trust the power of attorney really well because, you are essentially allowing decision-making authority to be done on your behalf, either under certain conditions or all the time. So, you lose your ability to have sole control. Now, the last column on this lovely, colorful slide is guardianship. And I always go from the green to the purple because most people don't know anything about those first four options. They start at the most restrictive thing you can do, which is guardianship or limited guardianship, depending on, that's just a severity of guardianship, really. And what guardianship is a formal court proceeding where somebody petitions the court and says, court, this person is legally incompetent to make their decisions. Here, I have demonstrated, I have proof. The person doesn't have an attorney that's representing them. They don't necessarily have somebody, it's not like Law and Order where you have a defense attorney and a prosecutor. You literally have a court that's asked to decide, is this person able to make their own decisions? And if they say no, then that person loses their civil rights to make some, in the case of limited guardianship, or all of their own, or most of their own decisions. And the court appoints a guardian, and that guardian now has legal responsibilities, roles, administrative requirements, and the ability to make decisions on behalf of the person. Our guardianship law in this state is pretty good, but that doesn't mean it's followed. Okay, so guardians are supposed to, under chapter 54.25, if you want to look it up later, they are supposed to honor the wishes and preferences of the ward to the greatest degree possible. They're supposed to make decisions that are the least restrictive on the person and least, in least restrictive settings. And there is a weight to what guardians are supposed to do when they're acting in this role, but there's not currently any training for them. And unfortunately, a lot of people get appointed to be a guardian and they don't read the statutes, funnily enough. People don't recreationally read the Wisconsin state statutes, as I do, to know what exactly is in there. For most parents with disabilities, I will be honest, this is where they start, and the conversation often goes like this. Oh, it's your child is 17 and a half. I'm your teacher, and I'm going to ask if you've gotten guardianship yet. And sometimes a teacher will say, well, you can't attend an IEP meeting unless you're a guardian, which is not true. Okay, not true, but we hear parents say all the time, well, I went and got guardianship because I was told by my teacher that if I didn't have guardianship, they wouldn't let me come to this meeting. When the child turns 18, all they have to do is give their permission to the parent to attend an IEP meeting, just like any other student who turns 18 and is, gets all of the decision-making authority that an adult has. But it's so assumed that if you have a disability, you must have a guardianship that people perceive it as an administrative step when it's actually a very, very serious legal meaning, and people lose their rights. And oftentimes families get a guardianship and don't understand the long-term consequences for decades. Guardianships are almost never overturned. There is a process in the law to do that. But once a judge has said that you're not legally competent, it gets pretty hard to prove that that was a mistake, right? Another judge has to say, well, was the first judge wrong? Did you gain new competence? It's just almost impossible to overturn. And frankly, it's expensive. So you end up with a lot of parents who get told by a system, maybe children's long-term care, maybe a teacher, maybe a medical professional. And some of these players have different reasons why they think guardianship is useful to them, right? Like a lot of times what you hear is, well, who's the guardian? Because they want to talk to somebody fast who can make a decision and they don't want to talk to necessarily the person, right? So in some ways it does become a thought process where it looks like it's an administrative thing, but in reality, what it is a long-term, lifetime, permanent thing that very often is not understood, and sometimes there are guardians that overreach and abuse, frankly. A lot of parents kind of without any, they have no mooring line, a lot of parents become a guardian for their adult child. They may be a guardian for 20, 30, 40, 50 years. I can't tell you how many times on this presentation that I get folks who have been guardians for decades who are like, what do you mean it's not inherited? What do you mean I don't get to say who becomes the next guardian? No, the court's in charge of that. What do you mean being a guardian isn't the same as being a parent? No, those roles are very different. So it's an extraordinarily serious thing. It happens to older adults too, by the way, but there's usually older adults have a record of decision making. But for people with intellectual developmental disabilities, it's almost assumed. And generally people go under guardianship at age 17 and a half and they never come out of it. And it has really serious consequences, not only for that individual person, but their families as well. So our philosophy is, don't start with the most severe thing you can do. Try out some other things beforehand. And if you need to get a guardianship, you need to get a guardianship. But you can do that at any point in time. You don't have to do it at 17 and a half. All right. So now we'll transition to supported decision making a little bit to explain what this law is and what it's intended to do. Really, these formal agreements are designed to help the person interact and communicate their decision with third parties, the bank, the healthcare professional, whomever they're interacting with, the state agency, right? Because a lot of them are maybe in different programs. And it really is putting the person in the driver's seat. They are in control of their own agreement. They're the ones who are saying, this is my support. This is the person I trust. I chose Tim to help me figure out my taxes. I hope you're good, Tim. The person is through this agreement saying, I'm in charge. This is who my trusted person is. Here is why they're here. Here are the things that they are doing here for me. And I'm still the decider. Look here. No, don't look there. Don't look at the other person. The supporter's not the decider. They have a very defined role. Look at me. I'm the person who's deciding. And it lets those other third parties know that, yeah, this person the supporter standing next to them, here's what they're supposed to be doing. If they're not doing that, they're not acting in the role they've been assigned. And it lets them know, hey, I have to reorient my thinking towards interacting with the person with the disability, because that actually is the person, the decisions they're making about themselves, they're the ones who get to decide it. So that's kind of the philosophical underpinning of why we have this law. In Wisconsin, we have kind of not a funny definition, but all of us use supported decision-making in our daily lives, but only some people in the state can use the formal supported decision-making agreement, which is, by the way, on the DHS website. So we broaden the law to make sure that people with intellectual and developmental disabilities, people with mental health conditions, people with physical disabilities or other conditions that limit major life activities, which federal law has something to say about, and people of any age with degenerative diseases or that conditions that interfere with the ability to provide self-care, all of these folks can use a supported decision-making agreement. We were very deliberate. We worked with older adult advocates on this bill. We're very deliberate to not include an age because, of course, things can happen at any age. So we wanted to make sure that the 50-year-old who has muscular dystrophy can use this agreement, that they don't have to be 60 years old and be in the same condition in order to take advantage of this. You self-assess whether or not you meet the definition of functional impairment. So there is no requirement for you to go to a doctor and be evaluated to see that you meet the definition of functional impairment. We were very deliberate about that too, because doctors should not be the arbitrators of whether or not you get to exercise your civil rights. They also are not there to fill out paperwork and other forms. They're there to actually be doctors. So we want to make sure that we're not putting our healthcare professionals in a position where they have to kind of be the decider on whether or not you can ask somebody something about your housing or your taxes. The other advantage that decision-making agreements have, when you think about that giant, colorful slide we spent so much time on, a lot of the decision-making assistance, when you think of powers of attorney, they are only good for like limited areas of decision-making. So like you can have a power of attorney for healthcare or for finances, but if the help you really need is where am I going to live? And is it next to a transit route, or is it time to move into assisted living or a nursing home, or can I manage where I am? It doesn't cover that. And guardianship isn't the right fit because even if you're losing your civil rights to make your own decisions, why would you want to hand that to somebody else when really all you have is a bunch of questions and you need some research? So supported decision-making agreements are far more flexible because the person can actually define what they need help with. So, you might have an agreement that says, okay, I want help with, I'll pick the first thing on here. I'd like help figuring out housing options for myself. Okay, you could have an agreement that's focused on that. You could have an agreement that's broader or narrower, and it can be tailored to whatever support somebody needs. And you can update it pretty easily. There's no court process. This is filling out a form and making sure that you have the updated form with all of the people who need to have it. So this is not supposed to be hard. It's supposed to be easy. Supported decision-making agreements, the person's always the decider. If you take anything away from this participation or presentation, the person's the decider. They are the ones who are writing the agreement. They write the terms of the agreement. They decide who the supporter is. They decide what the supporter is going to do, and they decide their own decisions. The supporter doesn't get any new rights. They can't decide things for the person they have the agreement with. They don't get to sign things for them. They don't get to act independently outside of the agreement. They don't get to share and disclose the person's information on Facebook or other things. They're really there in a role that's supposed to be helpful. But they don't gain any authority over that other person. And here they are. What can a supporter do? It's really limited to four roles under the law. You can help somebody get the information they need to make their own decision. How many times have, when you think about do you have all of your health records, or do you have you need to call the bank and you need to call your insurance company and you need to get two different things to figure out, something. A mortgage application. Do you have all your financial documents for your W-2s and all of that stuff? There's a lot of times when you might need to interact with third parties to get information in order to make a decision. A supporter can help folks do that. Why is that important? Sometimes, a lot of people have speech impediments or hearing loss or things that have nothing to do with their capacity to make their decisions, but it makes it super hard for them to interact with third parties and get what they need. This is a way that, okay, I have Melissa who's going to help me gather this information. And she makes a few calls as a supporter, explains she's the supporter, and says, hey, I'm requesting this on somebody's behalf, and it becomes easier. The second role is you can help somebody understand that information. I don't know if you've ever gotten a letter from a state agency. There is a language called bureaucratese that is very difficult for most people to understand. That's a role a supporter can play. If you've ever gotten an unclear letter that has like some sort of statutory citations, or you need to make several calls to figure out what it says, a supporter can help somebody do that. And that's really important for somebody who may not be feeling well, or maybe has an intellectual developmental disability. Not everybody reads. Sometimes, there's lots of reasons why that might be important. The third role a supporter can play is to help people understand their options, their responsibilities, their consequences. In other words, being a good friend, listening, as I'm sure all of you are, where your friend comes up with a problem and you kind of go, well, it sounds like you could do A, and you sounds like you could do B, or you could do C. And I think A, this might result, and B, this could be a result, and C, this could be a result. And then the person listens, your friend listens, and they make a decision. And they thank you for listening and laying out what the options are. That's a role a supporter can play. That isn't the same as saying, here are your three options, and B is the best. And if you don't pick B, I'm going to go to court and get guardianship over you because I think that you should have made a different decision. That's not what a supporter does. And the fourth role of supporter can play, and I will tell you, I underestimated the power and value of this fourth role when we were passing this law. It's to assist with communicating the person's decisions to others. I can't tell you how many people with cerebral palsy and other speech or nonverbal communication, like non-traditional communications, have highlighted that is actually the biggest thing for them in this law, is the ability to say, here's my supporter who knows me well, who knows my communication style and understands me very quickly. It's almost a translation, a personal translation service. And I can't tell you how many people have said, this is actually the only thing I use these agreements for, is to make sure that the person, the doctor, or whomever I'm interacting with understands what I'm saying. And in some cases, maybe they need help understanding what the professional is saying. I don't think anybody should go to a doctor's office alone. I don't care if you're, everybody needs two sets of ears sometimes, and somebody else who's asking questions too. So those are the four things. Get information. Do you understand the information? Here's these options and what they mean, and I'm gonna and helping communicate. You can't, just because you're a supporter, again, the law says you don't get access to everything. If I'm Tim's supporter, that doesn't automatically mean that I get to violate HIPAA and just get into any information that I want about Tim. Again, the person's agreement says if I have, if I'm a supporter for Tim and he wants me to help him figure out what car to buy, I don't have, that's pretty narrow. I don't get his healthcare information because of that. And frankly, I don't, even if I'm helping Tim with a loan, I may not get all his financial information, and I'm certainly not allowed to spread it all over the place, right? The requirement in the law is that you're acting as a supporter and that you're keeping that personal information, if you are aware of it, you know, between you and the person that you're working with. So how do you use these things? There's an actual form that was put into the statutes, and it's available on the DHS website. All you need to do is fill it out. It has real basic stuff like who's the name of the support and contact information of the supporter. You can select and write down what kinds of decisions you want support with, what role or roles. Remember, we discussed those 4 roles a supporter can have. A person can decide that they want you to do all 4 roles, or just 1 or 2 or 3. You know, if that's another way this is customizable. You choose a start and end date if you want. You can leave it open. You can make it very time limited or decision limited if you want. And then you need signatures, either 2 witnesses or a notary public. That's all you need to do. I'm not going to read the slide to you. The thing I want to draw your attention to is the last bullet. So there are things that we put on this form in the statutes that lots of people, like categories that lots of people want help with, especially people with developmental disabilities. But the thing that makes it the most flexible is this other decisions that I've specifically identified. That other category in the little blank line means you can fill it in however you want. And it means that it can be used for any kind of decision you want, as broad or narrow as the person decides. So it's very customizable. And you might say, you might say, I want a supporter. You could check multiple boxes. If you want the same supporter to help you with, you could have different supported decision-making agreements with different supporters for different things, because very few people have one person in their life that knows everything, which unfortunately is what guardianship assumes, right? Because the guardian becomes the decider for lots of different categories. That's not how real life works. Most of us have people that we would ask a certain set of questions to. Like my husband's a computer programmer. I'll ask him computer questions. He is not the person I ask for gardening advice on. You know, like it's just not the person. The other thing, the law assumes that you have to affirmatively give permission for a supporter to help you. So if you have a form where somebody hasn't checked no and they haven't checked yes, the law assumes that the supporter does not have ability to help with that kind of decision. This is just the link for where you find the form. It is perpetually online on the Department of Health Services website. You can download it and fill it out. You do not need to go to a lawyer. You do not need to pay a fee. It is designed to be something that anyone can access and fill out at any time. We often get questions about, well, how long are these good for? The person's always in control. The person's always in control. The person with who's making the agreement is always in the control. So that means they can decide how they want this agreement to work. And in fact, we have a whole toolkit on our website that really says you should be revisiting your supported decision-making agreements. Just as we would say you should be revisiting powers of attorney and other types of decision-making supports. Sometimes it makes sense to have a specific start and end date. Maybe you need help with one decision and you know when that decision has to be made. You could set up an agreement that's very specific to that. Sometimes it's fine to have it open-ended. Sometimes you might want to change the terms of an agreement at a different point in time, and it's designed to be easy to do that. So, if you're the person who's made the agreement, you can decide to change it at any time, and you don't have to do anything special. You could just, rip it up, do whatever. What we tell people is just make sure that whatever your new agreement is, or if somebody is no longer your supporter, you go back and update wherever you've left that supported discrimination, just as you would with guardian or power of attorney, frankly. Keeping track of where you've left your papers is always important, and updating them when they change is necessary. A supporter may also decide that they don't want to fill that role anymore, and they can terminate the agreement. Sometimes people want more or less help, or the supporter says, hey, I'm moving 3 states away. I can't probably fill this role for you the way you need me to. That's okay. Kind of reflects real life again, and sometimes people need certain things at 18 that they don't need at age 25 when our brains are actually mature, or 35. So we designed the law to kind of be open architecture, which probably dates me as a term, but it's open architecture, right? Like, you're supposed to be thinking about, does this still work for me, and making adjustments over time. And sometimes you might make adjustments where you need more help, or less help. We kind of covered this. You can have multiple supported decision-making agreements. I think for most people with disabilities, our goal is to have them have a rich network of friends and people in their lives, colleagues if they go to work, professionals that they know, to fill these roles. Unfortunately, a lot of people's lives are not as robust as we would like, but this supported decision-making agreement structure recognizes that there are many people who could play a role to help. It doesn't always have to be one person, and that the person can choose who they want to help them with decision-making. There are protections in the law to make sure that anybody who's receiving the agreement understands that they should honor it. That's pretty standard. But we had to put that in there because there are an awful lot of folks who look at somebody, see a wheelchair or a disability or age, and go, maybe I should be talking to somebody else. Maybe somebody else should be making the decision. This is kind of a way to say, nope, this is a paper that says I'm in charge, really. And we do know that families and people who have these agreements have to kind of assert themselves and act as their own advocates, because you're training a system that has been conditioned to think you are not as capable. Certainly anybody who suspects, just like our attorney or guardianship, if you are a mandatory reporter or a person who just sees something going on and you think, this is kind of funny, like this doesn't feel right, you can report your concerns to County Adult Protective Services or law enforcement. If you're a mandatory reporter, you still have to follow those requirements. So it's not anything new or different there. This was part of the law. The important piece here is the presence of a supported decision-making agreement can't be used as evidence later that somebody should have a guardian. And that's really important, because saying you need help should not mean that it's a sign you need your civil rights taken away and given to somebody else. Okay, and this law also changed. Now in guardianship proceedings, we're supposed to have our judges be asking folks if they've tried anything that's less restrictive than guardianship first. And schools are now required to provide information about alternatives to guardianship as well. In some cases, what schools were doing is saying, let's talk about guardianship and not talking about anything other than that. So why do this? And I'll kind of fly through this and then we'll have some questions. Why do we need a law in the first place? I've kind of probably beat we have systems that don't quite see people with disabilities as being their own decision makers a little bit, drum-wise. But the other there's some real practical reasons why you would use this. Lots of times people's closest relationships aren't necessarily with family members. Sometimes it's extended families. Sometimes people don't get along with their families, that they actually have a network of close friends that is much more engaged and knowledgeable about that person's daily life than other folks. And I think we have some assumptions culturally where we think families are the ones that we always turn to. That's often not the case. In fact, the advocate I worked on this bill with said, older women are frequently have a network of close friends. Maybe their husbands died, maybe their kids live in different parts of the country, or they never had children. The people who are in the best position to help them are not actually legally recognized because they're not related. And so this is a way for folks to formally recognize and give a role to a supporter who doesn't meet any of our system's expectations for who we think should step in. And that those people are recognized as having a role, and that they're not there to be problematic. Another big thing, and we've touched on this, is because supported decision-making agreements are flexible and can be changed and updated at any time, that means they're super useful if you need less support or more support. And I have a picture on here of an older couple. A lot of folks, especially those experiencing memory or cognitive decline, they probably need a little help for a long time. And maybe they need increasing help, but you don't go from 0 to guardianship in 2 days. There is a real need for this option to allow transition as folks need more support. Or in the case of our young folks with IDD, maybe they need a little more intensive support of it as a teen, but as they get more experience and learn from their decision making and their brains grow and develop and are adult at 25, maybe they need less support for a while. Supported decision making can accommodate both those scenarios. We've kind of already talked about this, but this is the option if you have decisions that you need to make that fall outside of finances or healthcare. There's all sorts of stuff that people need help with, and you can use this type of agreement for them. Folks who are hearing the message, I can't attend meetings, especially IEP meetings, you can have a supported decision-making agreement that allows you to do that. You can also coach your student to say, hey, I'd like to attend the meeting with you just as we've always done. Is that okay? This is, again, a way to train our agencies and that the person in front of them that they're talking with is the person with a disability, and they're engaged in their own life and should have be the primary decider of what's going on in it. Again, communication, I won't belabor this, but it's really helpful for folks to have somebody who can clearly communicate with others. It's also helpful for people who are professionals to have somebody who really is an expert in translating information to the person. You don't have to have a non-traditional communication challenge to know that some people hear things and need somebody who knows them to be able to kind of put it into terms that they understand. And this has been a theme throughout, but it really is intended philosophically to orient folks to the person as the decider. So, when you see somebody with their own supported decision-making agreement, they shouldn't have to advocate and fight to say, I am my own unique individual. The law presumes that I am competent unless the court has decided otherwise, but people do. I get asked all the time, well, why do we need this law? We need this law because we have some presumptions and biases that assume that if you look a certain way or speak a certain way or use certain equipment or are of an advanced age with a certain kind of diagnosis, that you can't possibly be competent, which is what the law presumes. So this is a way to try and make sure that we are all orienting ourselves around what the actual law is, which is to presume that the person you're talking with understands and is able to make their own decisions. A lot of times, we've done this presentation for both healthcare providers who work with children as well as teachers, and we talk with parents. And unfortunately, a lot of times the parents I'm talking with are already in the midst of transition. But when we get a chance to talk with teachers who are perhaps shepherding children through school, we always like to make sure that they know that there is you can't start too early with the idea of somebody being involved in decisions about their own life and getting practice at asserting themselves and having opinions. I think that I'm not throwing parents under the bus, but I think there's also a presumption that that is not there with students without disabilities, that there's always a need to involve the parent. And when you do that to the degree that the child is not part of their own decision-making process, and things are happening to them that are being discussed in front of them, we are teaching them something. We are teaching them that somebody else is in charge. And that is a very dangerous thing to do, because that's exactly what an abuser wants. I hate to say it that way, but I think there's always room for us as professionals to take a step back and go, every interaction that we do is teaching something. And if we want to have the outcome be that we have adults who are in charge of their own lives, who have dreams and hopes for a future, who want to be engaged and live in their community, we need to be setting them up for that success all the way through. And this is a way that you can practice those skills well before you get to 18. Okay, I am gonna, here we are. This is a year on Zoom, and I've just figured out how to stop share. So, yay. I see that there's some things in the chat. Let me just, Tim has been posting great links for resources on supported decision-making in the chat. If there's any questions or conversation, we have some time, and I'd love to continue the discussion.
So I know that was a lot of information, Melissa, but I know it's all new, but please feel free to unmute, ask any questions, put it in the chat if you don't feel like chatting out loud. That's fine. I think one of the things that I constantly pick up new things. So Melissa, what do you think tonight?
That was a lot of good information. So for a special education teacher and transition coordinator, when do you recommend like sharing that information with parents? Is there, is there a certain age, like DVR, they look, anywhere from 14 and up, and ADRC has a certain age. Is it like obviously before they turn 18?
So I'm going to answer in a couple of different ways. You're right. In Wisconsin, age 14 is kind of like the start of transition. And I think that's a perfectly appropriate time to start orienting families towards you're transitioning to adulthood. And this is an exciting thing, and there's lots of opportunities. You're going to see your child grow and continue to master new skills until they get to 18 and well beyond. And here are some things we should start talking about, like actually thinking about. And I say that because so often when I'm presenting, what happens to parents is they get inundated at all the same time with all sorts of systems that are asking them to make really consequential decisions. So for the person who might, with intellectual and developmental disabilities, for example, they are probably getting bombarded with how do we transition to the adult long-term care system. So they're moving, maybe if they're in the children's waiver, they're moving from the children's system, which is familiar, to an adult system. Maybe they're entering adult long-term care for the first time. So they're trying to figure out, do I choose family care? Do I choose IRIS? What do I talk to the ADRC about? I need to do SSI or SSDI applications. And guardianship gets wrapped in there as just one more administrative thing. So parents describe this kind of chaos and cacophony of information, and that is not how anybody makes good decisions. and they get overwhelmed. And frequently, the other thing that we see happen is because they're overwhelmed and they're making these consequential decisions all at the same time, there really isn't space for that family planning decision. And that's what I find the most, frankly, heartbreaking, is when you have parents who made a decision at a point in time 30 years ago, and all the people in their life at the time that they were making that decision, their teacher, their other, those folks haven't been part of their adult child's life for years, right? So, they're making a decision with people who they have known who have filled a certain role, and that role is going to change and disappear. And they haven't ever thought through, okay, if we go down the guardianship path, what does that mean for us 10, 15, 20, 30 years from now? Sometimes there are assumptions that siblings will take over. Sometimes siblings precede their siblings in death. Sometimes they move across the country. Sometimes there is a substance abuse or other problem or just a personality conflict where one sibling should not be in charge of the other siblings' decisions. And I think families have a really hard time thinking like that and talking to each other about it, but it's so important because there's so many people who end up having made those assumptions, and then they end up in their 80s and they're still the guardian. And what's going to happen next? And they don't even have any idea that they're, if nobody takes over, well, a corporate guardian will. That's often what ends up happening. So a long answer to your question, but I really think that we don't do a particularly good job as a culture talking about life changes and the future planning. And it is really a good opportunity at age 14 to start that conversation, because starting then, you do start making more rapid transitions. You get to 18, things are different. You get to 25, and now you have a mature brain and experience. You get to 30, and you're in a different place. And I think that setting the pattern that this is something okay to talk about and to keep revisiting is just really, really healthy.
And
Okay.
I just want to add, Melissa, that I totally agree with Tammy, and that's exactly why we have the whole information about youth health transition starting at 12 or 14 years old, because we want to build up those skills to be able to make those decisions. And so that's where we talk about being alone with the doctor, so you get comfortable with them being your doctor and not being your parent's doctor who is talking to them through you or talking to you through them. I mean, knowing your medication, knowing your healthcare, so you can make decisions about that healthcare instead of just mysteriously taking medicine and doing therapies without understanding why. Is we have to help our kids understand why are all these things happening to them, so then they can make decisions about their care, which is also why you'll hear me talk about, it's okay to put these decision-making and healthcare decision-making skills into the IEP and into the post-secondary transition plan. And they can work on them, because it's these decision-making that is going to be so important when they graduate, hopefully career, college ready as that person can be, that they are also ready to make as many decisions as they possibly can and make them well. Because if we can help them to get to 18, then maybe parents won't panic at 17 and a half, 18 years old, if we've been working on it leading up to that.
I have another question. How long is the turnaround, like once they start the guardianship process? How long of a process is that?
If George was here, he would say that you can take somebody's civil rights away in 15 minutes. We have a good guardianship law, but judges are not necessarily experts on people with intellectual and developmental disabilities or older adults. Oftentimes it is a county circuit court that does many, many other things besides guardianship proceedings that gets put in the position of, declaring somebody incompetent or not. Frankly, there are a number of factors that are supposed to be factored in by judges on whether somebody is incompetent or not. But we know in practice that the one thing that's required is a medical evaluation by a doctor. Doesn't have to be a doctor that has who has any particular experience or expertise in disabilities or anything else. And that judges tend to really lean on that. I will editorialize a little bit here. You don't have to have an attorney to go through a guardianship proceeding. There are many parents who go to the court's office, ask for the form, which is not a hard form. It has a bunch of check boxes, and parents often don't understand that when they're checking off those boxes, they are checking away. They are saying, yep, these are the civil rights that I want removed. And they find out later that the person's lost their right to vote and hunt and all sorts of other things. Because, you know, what happens when you do a form is we all automatically just fill out the form without knowing what's actually on it. And that happens to a lot of people. There are also examples of judges, parents or others who have been very intentional about, I want to only take away these rights to make decisions, but not those rights. You don't have to check all the boxes, right? And once you're in a guardianship proceeding, the judge is the decider. And sometimes they decide to take away all the rights anyway. You know, parents like to think that they're in control of this proceeding, but they're not. Once the court's involved, the court is always the one that's overseeing that guardianship and deciding how it's administered. So it is painfully easy, especially if you're a person with intellectual and developmental disabilities, to get a guardianship, to be placed under guardianship. You need a medical exam where a doctor says, yeah, I think that's fine. And you need a judge to say, okay, I think that's fine. And you know, there are some, you know, you've got to get the medical exam, so that takes some time, and you've got to have a court date scheduled. But the actual proceeding takes about 15 minutes in most cases. And it's never revisited. I mean, it's almost never changed after somebody is placed under guardianship. You know, very few people go back to the court to change the terms of those guardianships. And frankly, unless there's something really, really egregious that comes to the court's attention, the court is unable, with the volume of guardianships that have been granted, to fully oversee and make sure that each guardian is in compliance with the letter and the spirit of the law that requires them to not overreach their authority.
All right, thank you very much.
Well, if we are out of questions, I see no reason to stare at each other when there's a beautiful Monday evening out there. So thank you all for being here. Thanks for showing up. And Tami, thank you so much for presentation. Is it possible for you to share your PowerPoint with me that I can then send out to the registrants who maybe weren't able to attend tonight?
Yes, I will do that. I will do that directly. Thank you for having me. Anytime, it's always a pleasure to speak to your groups, and I just love this topic. So do not be a stranger, and give the board a call if we can be of help.
Absolutely. Like I said, we'll be coming back to you in the fall.
Okay, sounds great.
Thanks a lot.
Thanks, Tim.
Bye-bye.
Bye.